All right, hello everyone, and welcome to One Civil Law, where as always we learn through the misfortunes of others. I'm your host on Civil Law, and we are here with two Florida men cases to refresh our palate after the disappointment that has been the Murdaugh case out of South Carolina, which I had been covering up until just now because it made me sad. It made me sad because how do you make a double murder case boring? I don't know. But the state of South Carolina apparently has figured it out because it has been torturously, painfully slow. So we turn our attention to a state that always can make every other state feel better, Florida, where we have two Florida men of vastly different ages and vastly different dispositions, both relating to murders, but both showed up in court today and did something perhaps unexpected. So we got something that's a little bit different for you to help cleanse the palate. First, we turn our attention to the case of young Aiden Fucci. Young Aiden Fucci was 14. He currently is 16. He was accused and he pled guilty today, at the last minute incidentally, to stabbing a young classmate, Tristan Bailey, who was a cheerleader at Patriot Oaks Academy. Aiden Fucci, who was 14 at the time, apparently stabbed Miss Tristan Bailey 114 times. He used a simple folding knife, nothing really complicated, the kind you could buy for $10 at Walmart. Simple folding pen knife, you might call it, something you might give to any child. Well, he used his to stab his classmate 114 times, perhaps notably by breaking off the tip of his knife by embedding it in her skull. So, yeah. Her body was found about 3/10 of a mile from Fucci's house. They found the rest of the knife ditched in a pond nearby. They found clothing, blood-soaked clothing, in his house. They found clothing soaked in her blood. And also, somewhat unrelatedly, but I guess partially relatedly, caught her mom trying to wash the blood out of his jeans. So she's also on trial for destruction of evidence, basically, in a somewhat related case. Well, this case was set to go to trial, and today was supposed to be the first day of jury selection. The jurors, or potential jurors, had already been brought in to the outside world and were staying in a room, nearby, ready to be called in. And at the last minute, he pled guilty with no conditions. There wasn't a plea agreement. He just pled. No conditions. So that happened. The only reason that makes any sense is under Florida law. Well, it makes sense in two ways. One, the judge gets some sentencing discretion now. He cannot be sentenced to less than 40 years. But if the judge goes beyond 40 years, in 25 years, by Florida law, his case has to be reevaluated. He has to be reconsidered. So the only way this makes sense is basically he's throwing himself on the mercy of the court. He's throwing himself on the mercy of the court now, and he's throwing himself on the mercy of a court 25 years from now. But that's the only way this makes sense. So I thought we would watch his plea colloquy, where the judge asks him the sort of standard questions to make sure that he's doing this knowingly, intelligently, and voluntarily. We would watch his plea colloquy, and we could learn from that case. This is case one of two that we will be talking about today. So let's go ahead and do that. This is our young protagonist. And we're just simply going to watch this plea colloquy because it's always helpful to remember what one of these things look like, right? So the basic thing that the judge is trying to do in all these questions is to make sure that he's doing it knowingly, intelligently, and voluntarily. Do you know what you're doing? Are you sure that you understand what you're doing? Is anyone threatening you? Are you pleading guilty because you are guilty? That kind of thing, right? But it's always helpful to see how one of these things goes. So let's just watch it. It's only 20 minutes long. It's not that long.
All rise. St. Johns County Circuit Court is now in session. The Honorable Judge Smith presiding.
Good morning, everyone. Please be seated. Thank you. All right, we're here on the case of State of Florida versus Aiden Fucci, case number 21 CF 825. Who have a hearing on behalf of the State of Florida?
Jennifer Dutton.
And before anyone asks, I already have the volume completely maxed and volume booster on. So this is as good as it gets.
Johnson. On behalf of the defense.
Mercury Peoples and Craig Addick.
All right, and Mr. Fucci is also present here today as well. You can all be seated. We are here to begin our jury selection process. However, it's come to my attention that there may be a change of circumstances. Ms. Peoples, is that correct?
Yes, sir.
Okay.
Yes, Your Honor.
If you and your client can go ahead and approach the podium. Ms. Dutton, if you want to approach the bar. All right, Ms. Peoples.
Your Honor, on behalf of Aiden Fucci, we enter a change of plea at this time, entering a guilty plea as charged.
And this is a straight plea to the court. In other words, this is not a negotiated plea, is that correct?
Your Honor, we have presented several defense offers, and they've all been rejected by the state.
So it would be a straight plea to the court.
Yes, Your Honor.
No agreement. No agreement. That's what that means. No agreement. There is no offer from the state. He's just pleading. So, okay.
State, can you make sure that you state for the record the possible penalties that Mr. Fucci is facing if he enters this straight plea?
Yes, Your Honor, he's facing a possible sentence of life imprisonment. The mandatory minimum would be 40 years. So similar to after trial, the range of exposure is 40 to life. He will be entitled to a review hearing after 25 years of serving any prison sentence, Your Honor.
Ms. Peoples, have you had sufficient time to talk with your client about this decision?
Yes, Your Honor.
In addition, are his parents aware of this disposition, this proposed, not the disposition, but the proposed plea?
Both parents, yes, Your Honor.
And they've had an opportunity to consult with you as well as Mr. Fucci?
Yes, Your Honor.
Are there any other matters we need to address at this time before I place Mr. Fucci on the road?
No, sir.
All right, Mr. Fucci, if you could step over and speak into that, if you could adjust that microphone. Sir, if you'll raise your right hand, you swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right, sir, if you please state your name.
Aiden Sean Fucci,
Mr. Fucci, how old are you, sir?
16.
How far did you go in school?
To 8th grade?
Are you able to read, write, speak, and understand the English language?
Yes, Your Honor.
Are you under the influence of any medication, drugs, or alcohol right now?
Yes, sir, my medication, but
What type of medication are you taking?
Rimrons, lithium, and Suprexa.
Is that medication prescribed by a physician?
Yes, sir.
And does that medication assist you in your ability to understand what's happening and going on around you?
Yes, sir.
Have you taken that medication today as prescribed by your physician?
Last night, sir.
Last night, is that when you were scheduled to take it?
Yes, sir.
All right. And is it in any way, shape, or form affecting your ability to understand what's going on here this morning?
No, Your Honor.
Do you feel clear-headed and clear-minded about what's going on here today?
Yes, Your Honor.
Have you ever been diagnosed with a mental health condition that could affect your ability to understand and comprehend what's going on today?
No, I don't believe so.
Your attorney has informed me that you'd like to enter a plea of guilty to the charge of first-degree murder. That is a sentence that is a crime which is punishable by up to life in prison. the minimum sentence that the court could impose would be 40 years in prison. You just heard the state outline that range. Do you understand the range of possible penalties that you're facing if you enter this plea today?
Yes, Your Honor.
You understand that the minimum sentence that this court could impose for you would be 40 years in prison. You understand that?
Yes, Your Honor.
The court could impose all the way up to life in prison. Do you understand that as well?
I do, Your Honor.
And the way that this works is if the court were to sentence you to 40 years up to life, you would also be eligible for a review sentence of that sentence in 25 years. At that point, another body would then come back and review what we're doing here today, and they would look at that sentence and determine whether or not they should change that sentence. However, that's no guarantee as to what they're going to do. That's just something in the statute that requires another body to review this court sentence in 25 years. Do you understand that as well?
Yes, Your Honor.
Has anyone promised you any particular sentence that I might impose if you do this?
No, sir.
No one's said, hey, if you enter this plea today, the judge might, go lighter on you or anything like that? No one's promised you anything like that, have they?
No, sir.
You understand, again, I could give you 40 years up to life in prison.
Yes, I do.
You understand that today, we are here for jury selection. So we actually have members of St. Johns County who have reported to the courthouse today downstairs. They're actually waiting for us right now, and we were going to begin to select a jury to conduct a trial for you. You understand that you have the right to that jury trial?
Yes, sir, I do.
Your attorney had filed a motion, and we had a hearing a few weeks ago, I guess, where the state had requested a 6-person jury, and your attorney requested a 12-person jury. Do you recall that hearing that we had on that?
Yes, sir.
And you also understand that right now your attorney has filed a motion to an appellate court, which is kind of a higher court above this court. And their responsibility is to review all of the decisions that go on here. And right now she's filed that appeal as to whether or not you were entitled to a 6-person or a 12-person jury. Are you familiar with all that?
Yes, Your Honor.
Did you and she discuss the fact that by entering this plea today, you're kind of taking away that issue? In other words, there's not going to be an appeal anymore. Do you understand that?
Yes, sir, I understand.
Once you enter this plea today, that's going to go away. You understand that as well?
Yes, sir.
Is anyone forcing you or threatening you in any way to get you to do this?
No, sir.
Has anyone promised you anything in exchange for your plea?
No, sir.
I have a document here, it's called a plea form. It has the state of Florida versus your name and our case number. On the second page of this document, above the word defendant is a signature. Can you see that signature I'm pointing to? You
Yes,
have a
sir.
copy of it in front of you as well, is that right? Is that your signature?
Yes, sir.
And by signing this document, are you indicating to me that you've read this document?
Yes, sir, I read it.
In addition to reading it, did you discuss it and talk about everything that's on it with your attorney?
I did.
Did she answer any and all questions about everything that's contained on this document?
Yes, sir.
There's a number of rights that you're giving up. I've already talked about them a little bit, but I want to talk about them again with you, okay? You understand, again, that you have the right to a jury trial. During that trial, you're entitled to be represented by an attorney. You've got attorneys who are appointed to represent you. They would have been with you throughout that trial. You have the right to compel witnesses to come in and testify on your behalf. You could have testified during that trial if you wished, or you could have remained silent throughout that trial. You could have required the state of Florida to prove this charge beyond a reasonable doubt. You could have presented evidence during that trial. You could have cross-examined any witnesses that the state might have called against you. And you also could have appealed your conviction and sentence to a higher court. You understand, once I accept your plea today, there will not be a trial. We'll pass this matter off for sentencing, and you'll be giving up all of those rights that I just described.
I do, Your Honor.
Another matter that I want to address with you is another motion that we had previously discussed a couple of months ago, I believe, which was your attorney had filed a motion, was called a change of venue. In other words, she wanted to have this trial conducted in a different county instead of St. Johns County, as she was concerned about whether or not we would be able to impanel a fair and impartial jury. And if you recall, I ruled on that and I denied that motion. However, I stated that I would reconsider that if, after we had attempted to select a jury here in St. Johns County, if the court then determined that we could not find a fair and impartial jury for you, that we would move this to a different county. You understand that, again, once you enter this plea, that issue is not something that would be appealable anymore.
Yes, Your Honor.
You understand that now, that we're going to proceed here today with this plea, and so you'll be giving up that appellate right as well.
Yes, sir.
This is all standard, guys. This is all standard
You
plea
have
colloquy.
sufficient time to talk about this decision with your attorneys.
Yes, sir, I did.
Did you also get a chance to discuss it with your parents?
Yes, sir.
Have you also had sufficient time to talk with your attorneys about your case itself and any possible defenses that you might have raised to this charge?
Yes, sir.
I know that you were housed up in Duval County. Did that in any way preclude your ability to speak with your attorneys? Have your attorneys been able to meet with you and have conversations with you about your case?
They did.
Did you get to go over the evidence that the state has and that they've supplied in discovery? Have you discussed all that evidence with your attorneys as well?
Yes, Your Honor.
Do you need any time at all, any more time at all, to speak with your attorneys before I accept your plea today?
No, sir.
Are you satisfied with your attorney's representation of you?
Yes, sir.
Did your attorneys explain to you that if you were not a U.S. citizen entering this plea, could have subjected you to being deported from the United States?
Yes, sir.
And you've not ever previously been convicted of any type of sexually violent or sexually motivated crime, have you?
No, sir.
State, have you supplied the defense all of the discovery in this case?
Yes, Your Honor.
Are you aware of any physical evidence that can be tested for DNA that might exonerate this defendant?
No, Your Honor.
Ms. Peoples, have you had sufficient time to review all the discovery and discuss it with your client?
Yes, Your Honor.
Are you aware of any physical evidence that can be tested for DNA that might exonerate your client?
No, sir.
State, may I have a factual basis, please?
Yes, Your Honor. On or about May 9th, 2021, in the county of St. Johns in the state of Florida, the defendant, Aiden Fucci, did unlawfully kill a human being, Tristan Bailey, said killing being from a premeditated design to affect the death of Tristan Bailey. And furthermore, during the commission of said offense, Aiden Fucci used a weapon contrary to Florida statutes 78204, sub 1, sub A, and 775.087, sub 1.
Any objections or exceptions to factual basis?
For the purpose of the plea, yes, Your Honor.
You have exceptions or you do not?
No exceptions, accepting it for the purpose of the plea.
All right. I do find a sufficient factual basis for the charge of first-degree murder. Mr. Fucci, is it your desire to enter a plea of guilty to one count of first-degree murder?
Yes, sir.
I accept your plea. I find it's entered into freely, voluntarily, and intelligently, that you are coherent and alert, and that you understand the nature of the charges and the consequences of your plea.
I do.
We need to pass this matter off for a sentencing hearing. I know that this, we probably aren't ready to pick a date yet. Why don't we come back? Let's talk a little bit about what we need to do before we get to sentencing, so we hear from the state.
Yes, sir. I think if we want to state a discovery deadline where both parties have to disclose any additional evidence for purpose of sentencing, any witnesses that have not already been disclosed, and then from there, we can set a status in February if Your Honor would like, and probably pick a date sometime in February once we exchange those letters.
Pick a date for the sentencing out in March or April, is that what you're suggesting?
Yes, Your Honor.
Ms. Peoples, does that schedule work for you?
Yes, sir.
How long will both sides need to compile a list of witnesses for the sentencing hearing
I
itself?
believe 10 days would be sufficient, Your Honor.
All right, so 10 days from today, both sides will tender a witness list and any other discovery that they intend to utilize. Obviously, if there are letters of impact statements, things of that nature, I would expect those. But if it's anything of evidentiary value, that needs to be provided within 10 days of today. I'm also going to order a pre-sentence investigation. Ms. Peoples, are you requesting that as well?
Yes, sir.
And a predisposition report. I believe you would be entitled to that, so we're going to order both of those reports. So then we'll get working on both of those.
Your Honor, I just a special request with that order that if the court could note to the meaning DJJ, and to the, I believe it would be the sheriff's office, that defense counsel wants to be present for those interviews.
I will absolutely, we will notify them as well that you should be present for those interviews. Mr. Fucci, your attorneys are going to be present with you, but there will be, there's going to be a couple of reports that are going to be compiled for the court. They're going to be used as an aid to the court in order to determine what the appropriate sentence is. There will be someone who will come out and speak with you. Again, your attorneys will be present when that occurs. They may also speak to your family members, and then also the state and your attorneys, and also the victim's family members as well. So why don't we come back on February 23rd at 9 a.m. and we'll call it a status, and at that time we will select the date for our sentencing hearing. How many days do you anticipate needing for the sentencing hearing itself?
2, Your Honor.
2 days?
On the state's behalf, I would say reserve one for us, plus whatever.
Okay. Well, we'll set aside, we'll find 2 days. You all tell me when you both will be ready, and then we will select those 2 days. And then any hearings or any motions that we need to address on February 23rd, we can address those at that time as well. And I believe that covers everything. Is there anything else we need to address from the defense?
Yes, Your Honor. A point of clarification that Mr. Fucci had said that he read it, I actually read it out loud to him. It's a minor point, but I just wanted to clarify that on the waiver form.
The plea form?
That's correct.
Okay, so
And-
Mr. Fucci, when I asked you about whether or not you read it, your attorney actually read the plea form to you, is that right?
Yes, sir.
And she went over all those rights that I went over with you as well?
Yes, sir.
And she again answered any and all questions about everything that's contained on that document for you?
She did.
And your parents were also present during that conversation as well? Were they present as well?
No, it was a separate conversation with the parents. Your Honor.
Okay.
And Mr. Fucci just wanted to make a short statement.
I just want to say I plead out guilty, and that I'm sorry for the Bailey family and my family.
Okay. Okay. I'm sure that there'll be an opportunity, obviously, at sentencing hearing to speak again at that time, okay?
Yes, sir.
All right, any other matters we need to address? Anything else from the defense?
No, Your Honor.
No, sir.
All right, well, we're adjourned. We'll see you back here February 23rd at 9 a.m. Thank you.
Yep. So that's basically just what one of those things look like. That's all really standard. That's all really, really standard stuff. Knowing, intelligent, voluntary. The judge actually arguably missed one. He missed one question. And I don't know that it proposes a legal problem, but it's just a standard question. Are you pleading guilty because you are in fact guilty? The judge missed that question. The judge asked the attorney whether or not they were filing, whether or not they had any exceptions to the factual basis, but he didn't actually technically ask the defendant whether or not he was pleading guilty because he was guilty. And so I will note that for whatever legal value it has. I don't know that it poses a problem, but it is a standard question that was not posed. But otherwise, it's standard. This is what you're supposed to do. Just make sure you're not under the influence of anything. Make sure that you've not been threatened. Make sure you've not been promised. If you have been promised something, put it on the record. You know, all the rest of that stuff. So everything there is pretty standard. I did notice some people in Law and Crimes chat, or at least in their comments section, were like, "Oh, the judge is being really kind. The judge is being really isn't this really nice of the judge?" I'm like, this is legally required. Like the exact nature of it is some judges, you know, they play it a little different, but it's legally required. So, you know, it's per normal. And as to why he's doing it, the only reason that makes sense, well, as I say, there's 2 reasons that he's doing it, or 2 arguable reasons he's doing. Well, 3, I suppose. One is because he's just resigned. So there's that. I suppose that's a possibility. If we're looking at it from a tactical standpoint, one is that this judge will grant him mercy, and that in 25 years, whatever body that is that reviews those cases pursuant to Florida law will grant him mercy. And so he is looking to get himself closer to 40 years than not. So there's not less than 40 years. So he's 16 now. So he'll be in jail till he's 56 minimum. And he's hoping, I suppose, that between He's just throwing himself on the mercy of the court. So that's what's going on. So that was an unexpected thing that you might not have thought to see coming. Another case also happened in Florida today that you might not have seen coming, also relating to a murder. This was opening arguments for sentencing in relation to a death penalty case. So he's already been convicted. And today was the start of the hearing in relation to sentencing in a death penalty case. So I won't tell you a lot about the crime or spoil it because the prosecutor is going to give you opening arguments. And we will listen to the defense's opening argument. Just as a brief note over here, this guy is representing himself. He is pro se in his death penalty case. So that makes that notable. But there's arguably more notable things that happened today. So we will do that. So let's listen to this, the opening arguments of the sentencing phase of a death penalty case with defendant representing himself. Fantastic. Let's go ahead and do that.
Lorenzo, did you want to be heard, sir?
Yes, sir, I sure do. Before we get started, before they do the opening statements, there's a few things I would like to get into this court regarding getting these chat items into the court. We talked about this before. The state is coming up with maybe 12 to 15 pages of fantasy chat role play stuff and out of 11,000 pages.
Right.
Right. So I want to be able to, and I can't give this court 11,000 pages of documents. I'm just not going to do that.
I prefer not.
Yes, thank you. Yes. So what I'd like to do is, they're going to show only a very small section of what the whole thing is actually about. Well, what I've got here is from law enforcement, and what it does is it condenses all of them into screen names, and it explains what they wanted to do.
Well, I don't mean to cut you off,
Yeah.
I certainly respect you, but the way the process is going to go is they're going to go first. They'll have the opportunity to try to do whatever they want, and you can place objections. It sounds like there may be an objection when they want to put in testimony from the federal trial, and we'll address that at that time. Once they rest, I'm going to turn to you, and it's to be your opportunity to attempt to put in whatever evidence you want to put in, call whatever witnesses you may want to call, testify if you want to testify. But that'll come during your case in chief. So I'm not predetermining any issues. I know we have discussed it. I don't know what their position is going to be regarding it, but I do remember specifically discussing it. But I assure you that you'll have that opportunity once they rest their portion of the penalty phase, and I turn to you to present your portion.
Okay. Question 2. The penalty phase motions. There was multiple ones that were put in. This is phase 2 motions I'm talking about. I'd like to get the court to acknowledge that, Mr. Judge Kaiser, the denials of all these motions, so it's put on court records for, I guess, for the Supreme Court.
Right. These types of cases, if I was to sentence you to death in the end, are immediately go to the Florida Supreme Court for review.
Right.
Anything that's previously been done is on the record. I will reaffirm any rulings at this time by Judge Kaiser. I accept his previous decisions in this case, and they will continue to be in effect. Any objections to those are preserved for the record and can be argued on appeal.
Okay. And yes, the transcripts that they're going to put in here, you told me I'm going to object to these
I
coming in.
understand, and I'm not going to get to that until they attempt to
Do so.
So we're going to get started. I suspect they're going to do their opening. I'll give you an opportunity to do any opening that you wish to make. They're going to start calling witnesses, and then at some point later today, I'll take up those transcripts that I have of, I think it's 5 witnesses who testified in the federal trial.
Right. Beautiful.
And your objections.
Okay. Very good. Thank
All
you.
right, excellent.
Appreciate
Thank
it.
you.
Yeah.
All right. Madam State Attorney Lopez, are you ready to give an opening statement at this time?
Yes, sir.
You may proceed.
Thank you. May it please the court.
Certainly.
Mr. Lorenzo, Mr. Gonzalez, Mr. Dirks, and Mr. Diaz. Let's violate the world. Let's bring our fantasies to realities. I'm extreme, calculated, and love it. Easy to make them vanish with no link to us in the least. Easier to find a loner guy, less connection. I do a chokehold from behind. You hold him down, strap him up, not to be found again. He wasn't going to be going back. These are quotes from America Online instant messages between Master Scott, whom we now know is Scott Schweikert, and Dom Dude for Sub, who we now know is Stephen Lorenzo. These took place during the months of October, November, and December of 2003. Over the course of the next few days, you will hear more about these chats, and more importantly, the men behind these fictitious screen names and what led them to plan and ultimately execute the unthinkable, the unfathomable, in late December of 2003. First, you will hear from DEA Special Agent Albrecht. He investigated this from a federal angle regarding the illegal drugs that were administered to the unsuspecting victims to render them unconscious and render them helpless over the weekend of December 19th, 20th, and 21st of 2003. You'll also hear from TPD Detective Charles Masucci. He and TPD Detective John Columbia investigated this case. They investigated the two missing men whom you will learn more about, Jason Galehouse and Michael Wachholz. You'll also hear from Hillsborough County Sheriff's Office Detective Charles Keene. He is specifically involved because the body of Michael Wachholz was found in the county. Your Honor will have the opportunity to hear live testimony, not readback testimony, but live testimony of Albert Perkins and Jared Paraguay. These are two victims who survived the horror that is Stephen Lorenzo and were brave enough to come forward to law enforcement. You will see photos of the lifeless body of Michael Wachholz before he was wrapped in bed linens and left to rot in the back of his own Jeep, the Jeep that was strategically and purposely abandoned on the other side of town from where he was last seen. This was done purposely, and we know this because a discussion of this occurred in the chats prior to December of 2003. The court has been previously provided with copies of these chats, the chats that I previously mentioned. These chats give a glimpse into the minds of Scott Schweikert and Stephen Lorenzo. The chats lay out their ideas and their plans, and their desire to, as they said, quote, prey on the vulnerability of their victims. Most importantly, Your Honor will hear from Master Scott himself, Scott Schweikert. He'll tell the court how he and Mr. Lorenzo were linked together by Limit Expander, that is the screen name of an individual who linked these two gentlemen together. You will learn how their friendship, if you call it that, progressed. You'll learn that Mr. Lorenzo considered himself to be the experienced bondage master and that Mr. Schweikert was a novice. Both men, through the course of their, we'll call it relationship, from October to December of 2003, ultimately had the same goal. They wanted to find unsuspecting young men who were alone in bars. They befriended them and then invited them back to Stephen Lorenzo's house, which was on Powhatan Avenue within the city of Tampa, for some drinks and a consensual bondage session. However, Mr. Schweikert and Mr. Lorenzo had different plans. Once the young men were to get back to Mr. Lorenzo's house, they were going to, and I quote from the chats, use and abuse them to see how far Mr. Schweikert and Mr. Lorenzo would go, and to see how well they would work together. You'll hear about the night of Friday, December 19th, 2003. Mr. Schweikert was living in Orlando at the time, and he drove over from Orlando to Tampa to Mr. Lorenzo's house on Powhatan Avenue. A plan was in place. They went to 2606. That is a gay bar that's located at 2606 Armenia. It was there that they met Jason Galehouse. Mr. Galehouse accepted an invitation to go back to Mr. Lorenzo's house for some drinks and a bondage session. He even agreed to be tied to the bed. Then, just as had been discussed in those chats, in the months leading up to this night, Mr. Lorenzo, sitting on the bed, with Mr. Galehouse lying on the bed, tied to the bed, at his ankles and at his hands, did a chokehold on Mr. Galehouse from behind. At that point, Mr. Schweikert will tell you that he held down Mr. Galehouse's feet. Mr. Galehouse remained strapped to the bed. Mr. Schweikert will tell you that he fought, but ultimately, that chokehold is what killed him. And just as had been discussed in that text that I previously referenced, Mr. Lorenzo did exactly what he said he was going to do. He did a chokehold from behind. He was held down as Mr. Galehouse was strapped up, and he was never to be found again. The murder of Jason Galehouse is the very definition of cold, calculated, and premeditated. This is evidenced by the chats, as well as the testimony of Mr. Schweikert himself. In these chats, Mr. Schweikert and Mr. Lorenzo even refer to what they are doing as cold and calculated. After Mr. Galehouse was killed, his body was wrapped and put on a trailer in the driveway of Mr. Lorenzo's home. Mr. Schweikert and Mr. Lorenzo went to breakfast. They went to Home Depot to buy supplies. The supplies that they needed included contractor garbage bags, the large, very strong garbage bags. They then went back to Mr. Lorenzo's house. Mr. Schweikert will tell you that they carried Mr. Galehouse's body into the garage where he was dismembered. Head and torso stayed together. Arm, leg, and leg. The torso and the head were double bagged, as was each other body part, individually in double bagged contractor bags. Mr. Galehouse's clothes were also placed in their own bag, as well as the saw. At that point then, the two men drove around for several hours, distributing Mr. Galehouse's body parts throughout the area. Once was not enough, though. Later that evening, after they had determined that in fact they did work well together, they wanted more. Saturday night, December 20th, 2003, they went back to 2606. It was there that they met Michael Wachholz. He was alone at the end of the night and stopped by for a drink. They befriended him and invited him back to Mr. Lorenzo's house. Once they got back to Mr. Lorenzo's house, both Mr. Schweikert and Mr. Lorenzo had a role to play. Mr. Schweikert will tell you that it was his job, his role, to distract Mr. Wachholz, who was sitting on the counter between the kitchen and the living room with his back to the kitchen. Mr. Schweikert will tell you it was his job to talk to him and distract him while Mr. Lorenzo poured a glass of wine for Mr. Wachholz. He then drugged that wine, put in an illegal drug to render, ultimately, Mr. Wachholz unconscious and helpless. Things went off the rails rather quickly. Mr. Wachholz tasted the wine. There was something about it that didn't quite taste right, Mr. Schweikert will tell you. and Mr. Schweikert walked into the living room to find Mr. Lorenzo trying to hold Mr. Wachholz down. As he was doing this, Mr. Wachholz was yelling, was screaming, "This is not consensual. This is not consensual." At that point, Mr. Lorenzo grabbed a rag and grabbed a can of something called Maximum Impact. Its legitimate use, I submit to you legitimate use, is to clean keyboards. It is an aerosol can. It is also something, though, that when sprayed upon a rag and held up against someone's nose and mouth can render them unconscious. That is what made Mr. Wachholz pass out. Mr. Lorenzo holding a rag sprayed with Maximum Impact on the rag. They then stripped Mr. Wachholz of all of his clothes. They cuffed his hands, they cuffed his ankles, and they duct taped his mouth. Your Honor will see photographs of the unnatural position of Mr. Wachholz's legs over his own shoulders as he lay on his stomach. His legs were flipped up over his head. As he was losing consciousness from the Maximum Impact and the drugs that had been administered to him in his wine, Mr. Lorenzo then violently, you will hear from Mr. Schweikert, stuffed a rag, not the same rag, a different rag, stuffed a rag into Mr. Wachholz's anus. This, of course, is a sexual battery. You will hear from Mr. Schweikert that Mr. Wachholz was in and out of consciousness, but it was likely the force of that rag being shoved into his anus that made him regain consciousness. It was shortly after this that Mr. Wachholz, as Mr. Schweikert will tell you, died. The medical examiner indicated and opined that Mr. Wachholz died as a result of homicidal violence. His death at the hands of Mr. Schweikert and Mr. Lorenzo, working in concert with one another, was especially heinous, atrocious, and cruel. And it did in fact occur during the commission of that sexual battery. Mr. Schweikert will tell you about the cleanup, the photographs that were taken by Mr. Lorenzo of Mr. Wachholz, of Mr. Wachholz's body in that unnatural position that I mentioned. Many photographs of Mr. Wachholz's feet. Mr. Wachholz in a shower tub, appearing to be very much dead. You will hear about the decision to dump Mr. Wachholz's body in an open but unlikely location. As I mentioned earlier, his body was found in the county. It was found very far away from where he was last seen, and that was something that was discussed in the chats previously. You will learn that Mr. Wachholz, as I mentioned, was killed on December the 21st. That is the Sunday morning before Christmas in 2003. Christmas was a very important time and was specifically chosen by Mr. Schweikert and Mr. Lorenzo because losing a loved one at Christmas time would cause the families even more pain. Pain is what Pam Williams, the mother of Jason Galehouse, and Ruth Wachholz, the mother of Michael, have suffered for the last 20 Christmases. These two mothers, one of whom did not have a body to bury, doesn't have a grave to visit, have been delayed justice and denied justice for almost 20 years. And now is their moment to get justice. The state of Florida stands before your honor today to humbly ask you to impose the ultimate, the harshest, the most severe punishment allowed by the laws of this state. A sentence that is ultimately carried out by the governor and by the warden of the Florida State Prison. we ask you to sentence Stephen Lorenzo to death. The aggravating factors, it is clear, outweigh any mitigating factors that there may be. A sentence of death for Mr. Lorenzo is the only appropriate sentence. Thank you, Your Honor.
Thank you, Ms. Lo-
Well, that was a pretty powerful opening from the prosecution, wasn't it? I mean, she seems to think that he's really worthy of the death penalty. Let's hear from the defendant.
Lopez. Mr. Lorenzo, do you wish to give an opening at this time?
Just something real quick. Yes.
Certainly, absolutely. And I'm going to allow you to remain there.
Yeah.
And there's a microphone in front of you. Just make sure the green light is on. If you need to move it closer, you're welcome to do so. But I can
Okay.
pretty much hear you.
You can hear me okay?
Yeah, I can hear you.
Okay. That's a wonderful story. It's a very dramatic story, but it's a lie. It's a lie. Mr. Schweikert made up this story, and I made it very, very clear in my 160-something page that he made it up to appease the state because he was hoping he was going to walk from this case. So he was hoping that he could talk his way out of it, and so he gave them the story that they wanted to hear, and they conformed it with the fantasy role-play chats. That's fine. I don't really care. It doesn't bother me because the defense wants the death penalty. The defense is saying, yes, give me the death penalty. That is absolutely great. That's exactly what I want. I'm 64 years old. I could be on death row for 10, 15 years. The comforts that they get in the death row are a lot more comfortable than it is in the federal system. You get your own private cell, you get your own TV, you get your own computer, you get all this stuff. But your privacy, your daily quality of life privacy, at my age, is invaluable. I have a life sentence in the feds. I'm going to be in prison for the next 10 or 15 years until I would normally die anyway. I could be in the state for 10 or 15 years before they even get to me. I can possibly pass on before I even get there, but I want to be comfortable. I want to do my time my way. It's easy time. So I'm going anyway. As far as I'm concerned, everybody here is on death row. Everybody's got to go sometime. We've all been given a death sentence. And what the best the state can do is give me euthanasia. And that's how I see it. It's euthanasia. It's by choice. That's what I want to do. So I'm not arguing with the state. So what I'm going to let the state, I'm going to do my basic objections to certain things to keep things fair and balanced for the Supreme Court, because I know it's going there, and that's fine. But I'm really not going to try to counter their false claims. That's a false claim. They're twisting the facts. They're twisting it all around, and that's their job to do it. That's fine. But I'm not going to counter it because I want this court to make me think I'm the worst thing on 2 feet. I want them to continue to sit fat, because the more they think I'm the bad guy, the more further I'm going to the chance I'm going to get the death penalty. So I'm not going to try to argue that. I'm not going to try to counter it, even though it's so twisted. I'm beside myself. But I expect that. I put in what exactly happened that night on that document. I did that on purpose because I knew this was coming. And I'm not going to sit there and argue and try to change it, because I want you to believe it. Go ahead, believe it. That's fine. I have no problem with that. But I want you to see what really transpired, because that is fair to let you know exactly what happened. So I'm not going to counter it. I appreciate the state. That's fine. It was very dramatic. It was very good. But I just want to let you know that I'm in sync with the state. I have no issue with the state. I want the death penalty. And that's how I leave it. Thank you.
All right, thank you, Mr. Lorenzo. I'll ask the state, please.
Yeah, so that would be the thing that I knew that you didn't know. And that's why I was amused. Because, it's like surprise Pikachu. And if you're not a little entertained by that, I don't know what to tell you. But yeah. So yeah, he's like, well, I'm 64. And, I'm already life for the feds. And if I get the death penalty, I get to be put in death row, and that has some perks. And I like the perks, and I'll probably die of natural causes. And if not, I get euthanized. So win, win, win. Everyone's happy. So I thought that was amusing. It's also incidentally why he doesn't have a public defender, because as Steve Gosney has said, the public defender's office won't do this, which I think ethically is questionable, but I don't want to throw Steve Gosney under the bus unduly without talking over with him. But I think if your client is knowing, intelligent, and voluntary, and that's what they want, And, he has his reasons. And, you can debate with yourself, I suppose, as to whether or not those reasons persuade you. But, it's like, well, I'm in jail for the rest of my life anyway. It's not that long. And I get, all these creature comforts from the death penalty cell. And, it'll take 10 or 15 years to execute me anyway. And I get euthanized. And so I'm happy. So that happened. So those were two unexpected things. Those were two unexpected things that occurred in a Florida courtroom today. So I brought those to your collective attention because they entertained me. Yeah. So good times. So yeah. So the state wants to make its case. And, they want to prove their case just in case for some reason he changes his mind or something, right? They want to prove the case so that, it'll be established and proven for any sort of future appeals, because maybe he'll change his mind or whatever. It's like, well, no, we're going to actually prove our case and go from there. So, yeah. So the judge didn't order anything. That was the opening arguments. I think the sentencing hearing is supposed to take the next 2 days. I don't know that I don't know that I want to, nor could I stream it. Or that I really have any particular desire to, but it's available, I suppose, if you want to get access to that. So, yeah. They should never allow criminals to make off money. Most states have laws on the book for that thing. Son of Sam laws. So, he's going to be in jail for the rest of his life. The only question is where, I suppose, in some degree. Okay. So that was all those good things. So we got death? No, we haven't gone that far. It was the opening arguments. He's asking for it. He hasn't been sentenced yet. So I don't know. Did he do it alone? No. Apparently he had a co-conspirator. So, so there's been no determination yet as to whether he gets the death penalty or not. But that's where we're at. Anyways, thank you. Between your lighting, your shirt, and your amused attitude, your eyes are sparkling. Glad to see your spirits are up. My spirits are up because I'm not talking about the Murdoch case. Thank God. I can't do it anymore. I can't do it, guys. I'm sorry. I can't do it. It's a tedious nightmare. I'll wait for an interesting case with actual witnesses that are interesting in some way. The Murdoch case makes me want to ask for the death penalty. So, yeah. So, yeah. It'll get better. Just hang in there. I'm out, baby. I am out. Oh, Lord have mercy. Have they made it to the defense? No, and there's no end in sight because the prosecution got in all of its financial stuff. So, yeah. Come back for the defense? I might come back for the defense. The defense has got to be more interesting than this. I might come back for the defense. What about the tarp rain jacket? I can't be bothered to care at this point. I just can't. Guys, I'd like to think I have a fairly good attention span, but I have my limits, and you've reached the limits of my attention span on this case. I have been bored to such death. I no longer have capacity for caring. I can't. I literally can't. I can't even. It's all 3s, 5s, 7s, and 9s from here on in. Okay. So, So good times. If anyone unboxes more craps, I'm finished. The unboxing has been torturous, that's for sure. Yeah. Plus, the stream has not done what I wanted to on a professional level. I'd stick with it if the stream was more popular. I'd stream with it if I had more people there. I'd stick with it if it had done more of what I was hoping to do in terms of the channel, but it does not accomplish the goals. So not only is it painful to me personally, it is not productive for the channel. So I have no incentive to continue doing it, really. It's just not a good use of my time. It's not a good use of my energy. Play Fallout 4? Yeah, maybe. You're gonna stick it out? With it, when they're bringing in all this financial stuff, I feel like he's going to be convicted, and I feel like the odds on appeal are pretty good. They're going to make it. They're going to make. I can't see the same testimony twice. I've already heard from these financial witnesses. I don't need to hear from them again. You know, there's nothing there. There's nothing there. I didn't get a workout today, but I'll try to get one tomorrow. So that'll be exciting. You're not a quitter. Good times. I don't think he'll be convicted. The financial stuff is going to make the jury hate him, although the defense has a decent chance of turning it around and pointing to, well, here's a whole bunch of people who might have motive to kill these people. So we'll see. We'll see. We'll see. Uncivil Minecraft? I don't even know what that would be. Anything good on the Supreme Court future? Yes, as a matter of fact, although not super new. The 21st, I believe it is, 2 weeks, the Supreme Court is hearing case in a major case on Google dealing with Section 230, dealing with Google's liability. I think it was YouTube, but Google's the named party. Whatever. Anyways, for recommending content. So under 230C3 or something, the internet companies can't be held liable for the content of other people. We all know that very well. But this case is not about their liability for the content itself. This case is about the liability for recommendation of the content. Whether or not YouTube, Google, Alphabet is liable for the actions of its algorithm in recommending content that might in some ways be problematic. And that's the case that's going on right now. So that's a really, really interesting case. What is the liability for the algorithm? And I think the best answer right now from where I can see it is that Google and others have liability for the algorithm. Except maybe for the most basic search functionality. Like if it's just straight search functionality, I don't think there's that. But if it in any way biases or alters the recommendation or feeds you recommendations, I think that's an act on Google's part. And they're like, but it's the algorithm. It's yeah, but you're in control of the algorithm. So you can't escape your liability by just saying it's the algorithm. So especially if they can show, well, this issue is just dealing with, is it possible in principle? So I think the answer is yes, it's possible in principle. To what do you need to show in sort of reality? I don't know, but I would think that maybe it's either just like they're liable for it no matter what, or if maybe there's human interaction somewhere. Zoe says jury can't take notes. Why is it court or judge? It's usually by state law or state rules. The law forever has been jurors don't take notes. That's been the law forever. The exception is that jurors take notes. Now that exception is becoming more and more dominant, but it is, I think, still I'd have to look it up, but it wouldn't surprise me if the majority of the states still jurors can't take notes. I suppose it wouldn't surprise me if the opposite is true. But until like yesterday in legal time, jurors didn't take notes. So the change for jurors to take notes is a change that has been something that has been developing. So that's all the rest of it. Are we happy with the audio quality, incidentally, and all that stuff that we made that work and all the rest of it? And now I have even more control over my lighting than before, because before I could just have this little color wheel and it was imprecise, but now I can type in exact hex values. Ooh. So, for example, let's see. Let's change the LED strip to Clemson orange. Let's see. That would be F56600. What do you mean the color's not supported? Don't deprive me. Five six six zero zero. What do you mean the color's not supported? What do you mean the color's not supported? Goddamn app! You had me all excited. F5. Just FF? All you can do is FF? This is some bullshit. Well, I was all excited and they took my excitement away. Lame. Lame. How can you not do F5? You can just do FF. You can do like see everything. Oh, wait, F. Wait. All right, hold on. F. You can't do F5. This is a travesty. This is just a travesty and an abomination, and I hate it. Lame. Lame. Yeah, it won't take the number. It won't take the number. F4 and 2 run the room, that'll do it. F4. You'll do FF. D, E, F. Wait. E, F5. It'll do some F5. Do like yellow's F5. Well, anyways. I'm going to sign off for now and I'll play with the colors some more. If you've been enjoying this episode of Uncivil Law or whatever my channel's name is, please remember to do all the YouTube things, like, comment, subscribe, and all the rest of it. I've been Uncivil Law. Until later, my friends, try FF6600. Yeah, it does that. We got FF6600. So I guess that's close. I guess that's close. I've been on Civil Law. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye. It's the secondary Clemson code? Is it really? All right.